My name is Ido Tuchman, and I'm really excited to share with you some of my knowledge here on intellectual property law. Um, for like, as a introduction said, I am an attorney here in San Diego. I deal a lot of issues that have to do with coding, so this is a great venue for me to speak about what I do and some of the things that may affect your practice doing coding work. So before I get started, I am obligated to, by the California Bar Association, to give you some disclaimers. This presentation offers legal information. It's not legal advice, and you should consult a legal professional about your particular situation. Also, we're going to be talking about the law, which can cause drowsiness, so don't operate a motor vehicle or any kind of heavy machinery at any time during this presentation. Okay, with that out of the way, I want to give you a big picture of where intellectual property fits into the legal framework. So law is divided into a bunch of different topics. We have criminal law, personal injury law, and we have private property. And private property is basically the ownership of stuff. And private property is generally divided into real estate and personal property. And real estate is anything to do with land and stuff attached to the land. There's tons of laws on how you acquire real estate, what rights you have when you have real estate, and what your obligations are. And personal property is basically anything that's not land and not attached to the land. And that area of the law is generally divided into tangible and intangible property. Tangible property is stuff you can touch and move around, like cars, jewelry, and animals. And intangible property is anything you can't touch. And so we have things like financial property, like stocks and bonds. That's intangible property. And another big category of intangible property is intellectual property, which is what I'm going to talk about. And that includes copyrights, trademarks, patents, and trade secrets. So this is just kind of an overview of the different types of properties. I'm going to talk about each one in detail, but I wanted to kind of compare all of them on one slide so that you get an idea of the differences and similarities between the different properties. So we have copyright, and copyright protects creative expression, stuff like books, music, photos, and computer programs. Code fits in with creative expression. And copyright generally lasts for the author's life plus 70 years. Trademarks is anything that identifies the source of goods, like words, symbols, logos, designs. And a trademark can last forever. It's basically, as long as a business keeps using that trademark in connection with its goods or services, that trademark still stays enforceable. So there are trademarks that last for over 100 years. And then we have utility patents and design patents. Utility patents protect new and useful functional items, and utility patent lasts for 20 years from the filing date of your patent application. A design patent protects the look of functional items, the ornamental design of a functional item, and that lasts for 14 years from when the patent issues, the design patent. And finally, we have trade secrets. That's pretty much anything that is confidential that gives a business an economic advantage. And so trade secrets last as long as the information is kept confidential. So the biggest type of intellectual property that software developers deal with is copyrights. And copyrights protect original works of authorships. And the copyright statute lists different categories of works that can fall under copyright. We have literary works, audiovisual works, music, and it goes on and on. And software falls under literary works. And the Copyright Act specifically says that you can't protect the underlying ideas, procedures, and systems of a copyrighted work. So the Copyright Act says, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery described in the work. So you have a conflict because copyrights don't protect the functional aspects of the work, yet code, by its very nature, is functional. And so there's this interplay between what's protected under copyright and code that's functional. And because of that, courts give copyright protection to software kind of weaker protection. They really scrutinize and try to separate what's functional and what's creative expression in your code. And if you do sue someone for copyright infringement of software, there really has to be like a strong case of like copying or like a really like egregious act. The courts will look to see what's actually like expression and what's just functional here that doesn't have protection. So they're a little hesitant to protect code like they would, like, say, a novel or a piece of art. There's a lot more to it than that. But to the extent that you do have creative expression in your code, what you get is the exclusive right to reproduce, distribute, display publicly, and modify your work. So that's the copyright protection that you get. It's kind of a bundle of rights. A big part of copyrights is dealing with who owns the copyright. And if you have, so the default is the author of the work is the owner of the copyright. And if you have multiple authors, then each one gets an equal share of, an undivided share of the copyright. So if you're working on a software project and you have one developer that writes 95% of the code and another developer that writes only just 5% of the code, if that code is like impossible to divide out into separate products, then they each get half the rights to the copyright. The courts will not be like, oh, like you put in 95% and you put in 5%. They don't do that. You can have an agreement between the authors to divide up the copyright in a different way than 50-50, but the rule is that joint authors, unless there's some kind of contract between them, they each get an equal share of the copyright. And each copyright author can license and exploit the work independently of the other. So one author can give a license and the other author can give a different license. And the only restriction there is that they both have to have an accounting and share the profits with the co-authors of the copyright. So to prevent authors from going rogue and just start licensing away the product, you can assign your copyright. So typically authors will assign their copyright to a company and then divide up the shares of the copyright using like shares of the company stock. So an assignment is just basically transferring all your rights of the copyright to a other entity, like usually a business, but it could be an individual too. Now, sometimes you'll have a work made for hire, and in that case, the company itself is considered the author. There's no assignment needed. If you have an employee-employer relationship and the work that's done, the code that's being developed is within the scope of the employment of the developer, then the developer is not the author. It's the company that's considered the author. And that works very well for employer-employee relationships. But sometimes you'll see, I mean, there's trouble with it, but like, if you have an independent contractor that has a license has an agreement where it's a work made for hire, then you get into a lot of complications, because the Copyright Act specifically says that there's only certain categories of works that are eligible for a work made for hire agreement. And so you can see over there that you have collective works, audiovisual works, compilations. Those have been ruled by some of the lower courts to be a work made for hire for code, but it's never gone up to any like higher court, like a court of appeals. So the usually a software that's written by a contractor, even though the contract says it's a work made for hire, that is owned by the developer, and any kind of clause that says work made for hire is generally unenforceable unless somehow it fits into like an audio visual work. Let's say you're doing like you're creating a software game where there's audio visual components to it, then a court may say like, okay, that could be a work made for hire. But generally, work made for hire clauses in a contract for a non-employee are not enforceable. And even more complicating is the fact that California, there's a law that says if you're under a contract for a work made for hire to develop code or any kind of commissioned work, then you're considered an employee. And so then the company that hires you as an independent contractor is liable for any kind of for workman's comp, insurance, and all those other things that they may have not anticipated because they had this contract clause that says you're a work made for hire. So generally, if you're a company looking to have contractors as developers, you want to steer clear of a work made for hire contract. You want to just get an assignment from the developer. So how long does copyrights last? For a developer that owns the copyright then the copyright lasts for the life of the author plus 70 years. If it's a work made for hire where it's a non-human entity like a LLC, then the copyright lasts 95 years from publication or 120 years from its creation, whichever comes first. And then, so how do you get a copyright? A copyright is created automatically as soon as you fix your code into a tangible medium. So computer memory would be a tangible medium. So you don't need to do anything more. You automatically get rights to the copyright. And you can put a copyright notification, usually it's a C in a circle, the year it's created, and then the owner. You can register a copyright with the Copyright Office, and there are benefits to registering, but you don't have to. Some of the benefits to registering copyright would be being able to sue someone in court for copyright infringement. You can, if you register your copyright, there's a presumption that your copyright is valid, and if somebody infringes your copyright after you register the copyright, then you can get statutory damages and attorney fees. And I do want to mention that even the copyright notice is not required to have copyright protection. Okay, so the next form of IP protection is trademarks, and I wanted to talk about it because it happens to be very topical these days, with Facebook changing its name to Meta, and I think there's a lawsuit now for trademark infringement for Facebook. So what is a trademark? It's a source identifier for goods or services. So a logo, a slogan, a name, anything that you use to identify your goods. And we're all familiar with trademark. It's how we, go out as consumers and pick what it is that we're trying to buy. So The way you get a trademark is you have to use it in connection with commerce. And you get protection for a particular type of good or service that your trademark is attached to. And it's only good in the geographic area that you're using your trademark. So if I open up a lemonade stand in San Diego and I call it Ido's Lemonade, I have a trademark in San Diego or wherever it is that my customers find me. I don't have protection in, say, San Francisco because I'm a local business. So trademark is regional unless you do something to expand that use. And I'll talk about that in a minute. A trademark gives you the right to stop others from using confusingly similar marks. So if somebody else uses your mark for the same types of goods or services, then you can stop them from using that mark. So similar to copyrights, you get trademark protection automatically as soon as you start using the mark in commerce. So it's all about use. You don't get any rights until you're actually using your trademark. And if you can register your trademark with the trademark, you can register it federally, and what that gives you is national protection. So once you register your trademark in a federal Patent and Trademark Office, then you have protection all over the US, and then you can use that R with a circle that we're all familiar with. If you don't register it federally, then you can give notice of your trademark using a TM for goods and SM for services. Utility patents, they protect new and non-obvious processes, machines, and composition of matter. So these are basically inventions that we think of when you think of patents. And software is eligible for trademark protection. However, courts have ruled that abstract ideas, mathematical formulas, methods of organizing human behavior are not patentable. So there is, if let's say you invent some algorithm, some software that is very generic, you may not be able to get patent protection for that algorithm because it may fall under an abstract idea or a mathematical formula. What may happen is that you may have to limit your application of your algorithm to a particular technology or to specific hardware, or somehow restrict it so it's not considered an abstract idea by the patent office. And so utility patents, they give you the exclusive right to make, use, sell, and import the invention. And I didn't mention this with copyrights, but a copyright, if it's all about copying your expression, and if somebody else independently creates a similar expression, then there's no copyright infringement. It's only when somebody actually looks at your code and then uses that to create something the same or similar is when you have copyright infringement. If somebody independently created code without referencing your code, then there's no copyright infringement. Utility patents are different. It's kind of a race to the patent office. If you have an invention, the first person that files for a patent, and that patent meets the criteria that the patent office looks for, a novel, non-obvious, and a bunch of other important requirements, then anybody that comes along later, and even if they independently create code, will infringe your patent. And the way you get a patent is you file a patent application with the U.S. Patent and Trademark Office. It gets examined, and if it meets the requirements for the patent office, you get issued a patent. as I said before, it lasts 20 years from the filing date of the first non-provisional application. So I have this timeline here. You can see you have your patent filing, and the time between the patent filing and issuance, that's the examination period. And in that period, you can't enforce your patent on anybody because it's still pending. You can say patent pending, but you can't take somebody to court. Once you get an issued patent, then you have enforceable patent rights, and anybody that infringes your patent between the time of issuance and the expiration of your patent is liable for patent infringement. Again, so who owns a utility patent? So the default rule is that the inventors are the owners of a patent, and just like copyrights, if you have co-inventors, then they each have rights to the invention. But unlike copyrights, there's no accounting for co-inventors. So any inventor can go and exploit that invention and give licenses without having to split the profits with the other inventors. Now, you can assign your patent rights to an employer or some other entity, and that's usually what happens in an employer-employee relationship. When you get hired, they have you sign an assignment for any future patent applications that you may have. So courts are they think it's against public policy, and rightfully so, to assign anything that you create to a company. So courts have been restrictive on what an employer can actually claim as an invention by their employee. It has to be related to the company's business goals. So it's not like you can, your passion project on the side that has nothing to do with your work. The company can't claim that. There has to be some relation to the job. An employer, if there's no assignment from the employee to the employer, in some cases, a company can get what's called shop rights, which is like a limited license. If that employee created the invention using company time and company equipment, then the company is eligible for like a limited license to use that invention without paying royalties to the employer. And there's also a hire to invent doctrine, where if an employer hired an employee to solve a specific problem, and it's a very narrow type of hiring of that employee, then in some cases an employer can get patent rights to the invention that employee created. But it's very narrow. California labor law says that everything that an employee acquires is owned by the employer. Courts have said that doesn't apply to patents unless a company really like hired that person to invent something new. Design patents. Now, unlike utility patents, design patents protect the look of a functional item. So it has to do with new and non-obvious ornamental features of an article of manufacture. Design patents don't protect the functional aspects of a product, but graphical user interfaces are protectable under design patents. And the picture that you see up here, that is Apple's user interface for the iPhone, and this design patent was part of a portfolio of patents that Apple used against Samsung, and they got I think $500 million jury verdict against Samsung. So they are powerful. The user interface still has to be new and non-obvious, and just like with utility patents, everything is similar to the ownership and how do you acquire it. You file an application. The only difference is that the design patent lasts 14 years from the issue date rather than 20 years from the filing date. And the last intellectual property that I want to talk about is trade secrets. And this is basically that it's information not known to others that has economic value to the company and is subject to reasonable efforts to protect its secrecy. So a lot of companies will lock down their source code. They'll keep that as a trade secret. And that basically lasts for as long as the company can keep it a trade secret. They limit the employees' access to the source code based on a need-to-know policy, and they don't go out and disclose their source code. So as long as they do that, they get trade secret protection. And so what you get is damages for misappropriated trade secrets. So any kind of theft of the source code, corporate espionage, or violation of like non-disclosure agreements. If it's a trade secret, then you can get damages for the loss of revenue, any kind of injunction to keep that trade secret from being disclosed further. And if you have like if the other company gets profit from the trade secret, you can get damages based on their use of the trade secret. And I think that's about the right amount of time, right? So I've rushed through this. I mean, I could talk about each one of these for like an hour. So I just wanted to give you like a glimpse of what's going on here. And here's my name and contact info. And if there's any time, I'm happy to take questions.
Yeah. Does anybody have any questions for Ido?
Yes.
What if they don't pay you?
Who?
Whoever hired you to make a work of.
So if let's say if you're a developer and you have an agreement to develop some software with a company, you own that copyright for the code, and you can structure a contract where it says that they only get a copyright, they only get assignment of your copyright once you're paid.
What if you're an idiot and you didn't do that?
Well, I mean, it's automatic. So you're still the owner of the copyright, and you may have to hire a lawyer to enforce it, but yeah, you have copyright protection on your code. Yes, sir.
I was going to say, most jobs I get, I have to sign that up front, and I don't have a lot of leeway on what language goes into that.
So the question is like, I don't have any bargaining power for most jobs, and there's not a whole lot you could do with that except look for other clients and then try and make sure that you have some kind of agreement where, yes, I'll give you the copyright, but only upon like final payment for my work. There is definitely like some situations where there's an imbalance of bargaining power, and sometimes you have to you give that up front. I mean, I have clients where I have big clients where I do a lot of work up front and then I get paid later. Thankfully, the bigger clients tend to be the ones that pay me every time. But if you have a smaller client, you have more bargaining power. So that's the only thing I can suggest on that. Yes.
Trade secrets, like you don't have to apply for anything, right? You just claim it's a trade secret, I assume?
Yeah, the question is, how do you get a trade secret? So yes, a trade secret is, it's not a federal law, it's a state-by-state law. Most states have very, very similar laws. You just have to, keep your information secret. It has to have economic value, and you have to use reasonable practices to protect it. It's just like, like laws against theft, that somebody can't come into your house and steal your bicycle. You don't have to do anything. That's just against the law. And it's the same thing with trade secrets. You know, there are even criminal penalties for theft of trade secret, but there's nothing that you have. There's no like trade secret registry or anything like that. Anything else? Okay. Well, thank you so much. I really enjoyed talking with you guys.